What is the difference between a personal injury claim and a personal injury lawsuit? Hi, I'm Josh Rohrscheib. I'm an injury lawyer in Central Illinois, and often these words get used interchangeably, claim and lawsuit. But they're really two different parts of the injury process. So at the beginning of the process, we open a claim, typically with the at-fault party, the at-fault company, the at-fault driver's insurance company. We'll send a letter to that insurance company, let's say, and we'll open a claim. And then when our client is done treating and has recovered from their injuries, we will put together something called a demand letter that has a lot of supporting documentation, maybe photos of the vehicle, police reports, all of our clients' medical bills and records, proof of wage loss, pictures, other evidence that can help the insurance company understand the impact of the incident on our client and their life. And then we'll send something called a demand letter with these supporting materials to the insurance company as part of an insurance claim to see if we can get them to offer our client a fair amount of money to resolve their claim. And that's the claim portion of the injury process. In most cases, more than half of our cases, we're able to achieve a settlement for a client in the claim part of the process. Unfortunately, some of the time, we're not. Some of the time, the insurance company has a dispute about what happened, or some insurance companies, just part of their business model is that they will not offer fair settlements to clients. And in those cases, when we can't achieve a fair settlement in the claim phase of the case, the leverage that the client has is to file a lawsuit against the at-fault party. Then that party's insurance company will have to hire a lawyer to defend them in the lawsuit. Now, negotiations can continue to try to settle the case after the lawsuit is filed. So the claim kind of stays open throughout the process. But the lawsuit, the personal injury lawsuit, typically only happens if the claim cannot be resolved successfully in the first few phases of the personal injury claim process. And if it can't, then we file a lawsuit. Now, the good news for our clients is, again, in most cases, we can resolve the claim for them without ever filing a lawsuit. And there's some advantages of resolving things in the claim process. First, it gets the case done a lot faster. So you can get your medical bills paid, stay out of collections, and get the financial benefit of your injury settlement without having to go through years of litigation. Second, the second advantage of resolving a case in the claim process is certainty. If you have a negotiated resolution, both sides have come to an agreement on the value of the claim and work something out, and there's certainty. And with a lawsuit, if it were to go all the way to a trial, the value of the case is whatever 12 folks from your county or the county of the accident may decide that the case is worth. A third advantage is cost. So if a claim can be resolved at the claim phase before a lawsuit is filed, the costs to the client are usually a lot lower than if a lawsuit is filed and we have to pay experts and engage in a lot of depositions. The litigation costs can grow, and at the end of the case, those are reimbursed from a client's settlement. So you typically have to recover significantly more in the litigation process to offset the added costs. Well, I hope this explanation is helpful. If you have any other questions about the personal injury claim or litigation process, please don't hesitate to reach out. And I appreciate you taking the time to watch this video. Thanks.